Hi, my name is Paul Kuhl. I'm president of the foundation supporting OMG K. Today I'm here at Yo Co-working as part of the second workshop of our Dragon's Cave Pre-Accelerator, our growth program for early stage startups. Today we're going to be talking about legal considerations for founders at the beginning of their startup journey. Our expert today is Jan Marczyński, lawyer at JWMS Law Firm, an expert on the legal side of tech entrepreneurship. Without further ado, it's my pleasure to introduce Jan Marczyński.
Hello guys, my name is Jan Marczyński. I'm an attorney at law, partner at GWMS Law Firm, and here I am today to tell you something about legal consideration for early stage startups. First thing that many people consider is when should I actually incorporate a company or officially start my business. There are reasons to wait and there are reasons not to wait. Waiting lets you focus on your idea, not on the formalities. Many business developers will tell you that focusing on the formalities makes you lose your steam and waste your time instead of actually developing your idea. Incorporation costs may be quite high. You pay for registration, you pay for bookkeeping, or for an address of your registered office. And when you wait some time, it's less risk that you will give equity, that you will give shares in your, let's say, in your company, to someone that will, in the end, leave and not be interested in following your dream. And of course, you have more time to determine your roles within the team when you wait with starting your company. Why you shouldn't wait too long? Because paying clients are the best proof for investors that your idea makes sense. And getting payment requires at least registering some kind of business so you can issue invoices and pay your taxes. If you are closer to the viable product, the value of your product is bigger, so transfer will have more tax results. You have to remember about that. And incorporation makes it easier to secure IP transfer, so you have less risks that somebody will leave your team before transferring what they made to you. Just to look at the legal forms that are possible in Poland, of course it's not all of them, but most people in startup world in Kraków use either sole trader, individual business, jednoosobowa działalność gospodarcza, because it's simple and it's a good idea for simple bootstrapped projects, typically made by one person. You don't really need some kind of protection against liability. However, it limits you in many ways, because limited liability company allows you to get investors easier, allows more co-founders to join in. There is clear division between assets of the company and your private assets, and you have the limited liability company, hence the name, the limited liability of your for debts of the company. However, it has higher costs, higher maintenance, and it's still not as flexible as many people would expect. For example, it is much harder to liquidate limited liability company than to stop individual business. But still, most startups in Poland use this form. And something that we hope will be introduced finally into Polish law, simple joint stock company, prosta spółka akcyjna. It will be available hopefully from March 2021. It should answer some needs of startups, however, the date has already been postponed once and it may be postponed again, but let's hope for the best. When you set up a company in Poland, you can do it in what we call traditional way, so you make articles of association as a notarial deed. It allows for custom-made articles of association, umowa spółki, which is the basic document of your company. However, it takes more time to register it requires meeting in notarial office. So if you're doing it with an international group, it can be more of a problem, because in case of people who don't speak Polish, they will have to have a strong translator with them. In case of people who can't come to Poland, they will have to send notarial power of attorney. Internet registration, S24 registration as it's called, allows only for articles of association based on a very simple template, not much to choose from. But it is quick. It can be done with people all over the world. However, there is one problem with that. You need to have either what we call qualified electronic signature or ePUAP signature. And ePUAP, for example, requires you to have a PESEL number, so Polish Social Security number. So while it allows you to do it without meeting in one physical place, before that, it may require some more effort. Co-founders have to remember that after a company is created, they have the rights that they all agreed upon. Let's say in some kind of contracts, in the articles of association, in what we call co-founders or shareholders agreement. But before registration, you only have some rights if the law gives them to you. So for example, software developer has copyright rights. However, somebody who developed the ideas for marketing may not necessarily be compensated for it if the co-founders group splits up. Before MVP, you should think about, first off, checking the IP, so intellectual property, chain of title, so whether anybody who has made something that is protected by law has transferred their rights to whoever would be monetizing the project. You have to remember the tax implications. For example, incorporation may be required if you're getting revenue. You have to check all the regulatory issues. The fact that you are just on the early stage does not necessarily exclude you from any kind of requirements related to personal data protection, anti-money laundering regulations, or supervision over financial markets, or environmental issues. And in case of B2C, you have to consider consumer protection. So if you're selling something or providing services to consumers. Several things that you have to remember, some of them I said just a second ago. Law changes a lot. So as I said, next year we may have a new form of company, and next year the way we register companies may be completely different. Waiting too long with formalities, as I said, may lead to some legal problems. You shouldn't assume that contracts are signed only because you do not trust people. You should remember that contracts are signed so you can sit down and verify whether your idea about the project is the same when you stipulate it on paper. You should remember that advice that is too good to be true is usually not true, and that there are many regulations that can influence whether your business is even viable. An important thing most startups have to remember about is that in Poland, transfer copyrights requires written form. So you should have a written agreement if you want to acquire copyrights. And that's all. So, as I said before, my name is Jan Marczyński. I'm an attorney at law, partner at GWS law firm. If you have any questions related to your tech startup, to your business idea, feel free to reach out to me on social media or wherever you will find me, and I'll be happy to help you. Thank you.
Nice.